Being a paralegal for Stephanie Grana is not the easiest thing because literally 5 o'clock comes and goes. And then they might be in the doorway saying, "At 6, do you need anything?" And I'm like, "I'm so sorry, it's 6. I have no idea what the time is." And being my husband is the most difficult job because, "Steph, we're supposed to be at dinner." And I'm like, "Oh my God, I just got this great call. I got to do this, I got to do this, and I got to do that." He's, "Tell me your appetizer and I'll take care of it, but please then get in the car and come." He's a very patient man.
This is RVA Trial Lawyers, Virginia's trial lawyer podcast, hosted by Sharif Gray and Niall Abuzaki.
All right, we're back. RVA Trial Lawyers, thank you so much for joining us. Stephanie Grana is a longtime trial lawyer in the Richmond, Virginia area, and she is a partner at Cantor, Grana, Buckner, Bucci. And her accomplishments, frankly, are just too long to list. Former Virginia State Bar, numerous results in the 7-figure range, even 8-figure range when it comes to personal injury cases, and all around just a really good and giving person and someone many of us look up to in the plaintiff's bar. So Stephanie, thank you so much for joining us today. If you wouldn't mind, just go ahead and introduce yourself.
Certainly. Thank you for having me. My name is Stephanie Grana. I'm an attorney here in Richmond. I do like to say trial attorney when I can to make that a distinguishing feature. And I did look it up before coming today because you forget, but I have been an attorney 32 years now, and just saying that surprises me.
Wait till you get to my age, and then you really start to feel it. Nah, age is a mindset.
That's exactly right,
So,
because I'm quite older than you, but that's okay.
yeah, we'll see. Anyways,
I have to tell you, as a litigator and as a female litigator, I do find myself now walking into the courtrooms or the depositions, and I look around and I am the elder person in the room. But I agree, if you don't feel that way and you don't act that way, then nobody knows your age.
That's right. And things are always changing, right? And so when it comes to this line of practice, which makes it fun. So let's start off with trial attorney. Why emphasize the trial part of that versus litigator?
It's my passion. It's what I like doing. And I have learned, I will tell you, when I became state bar president, and then when I traveled the state as the president and engaged myself in various conferences, groups, meetings within the state bar, I had no idea how many types of attorneys there are. So I almost think that after being the president of the state bar, it's more important to say trial attorney. And as I had mentioned earlier, I do have a daughter who's now an attorney, and she has nothing to do with my practice. And so I think it is a real distinguishing feature. And I think that anyone who is an attorney and hears that you're a trial attorney, they just know that you have a different practice than they do. So I think it's very descriptive of one's practice, and I think it means a lot. And that's what I enjoy doing, and that's my passion.
I like the title trial attorney. I really do, because I think when you say it, it means someone who's willing to do the work to actually go to that courtroom, and also willing to assume that risk with their client and put themselves out there in a courtroom, which is just not easy to do. Let's get into your background. How did you find your way into this line of work?
I have 3 children, all adults now, and this part of my story sort of upsets them almost, but I have always wanted to be an attorney. You always find the people out there and they say, "Oh, when you were growing up, you liked to argue." I just thought being a lawyer, it wasn't just that it was cool. It was just, that's what I liked. I grew up in Long Island, New York, and I saw different things that I felt needed correcting. I went to public schools until high school. I was telling someone the other day that I was a minority in my high school, being a Hispanic woman. I went to an all-girls high school, which was a bit difficult, but there were a lot of issues, difficulties at my local high school. The police were in the parking lot of the high school often, and my parents really did scrimp and save so my brother and I could both go to private Catholic high schools. I did the debate team there. I really enjoyed it. I liked the organization of arguments. I will readily admit I liked winning my argument. I liked being the better oral advocate. I was very athletic in high school, and you have to be disciplined to be an athlete. And then I came to Richmond, Virginia to go to the University of Richmond. I will tell you that I loved the University of Richmond. I loved Richmond, Virginia. Thank you to the University of Richmond because they gave me the most money And that's what enabled me to come to the University of Richmond. I had a partial academic scholarship, a partial swimming scholarship. And I think part of the reason my parents sent us to private high schools was so that we would have better opportunities to go to college. My brother had gotten a full ride to Fordham and ran track and attended Fordham. And then I went south to the University of Richmond, and I loved it. I did not look back at New York. The cost of living was better. The people were nicer. The traffic was less congested. And I even learned through the assistant coach on the synchronized swimming team that you could graduate college, get a job, and own a home, which is what she was doing. I'll never forget that. And I just enjoyed the pace of life in Richmond better. So when I went to the University of Richmond undergrad, I knew even then, again, to the disappointment of my children who try to figure out what they're going to be, that I wanted to be a lawyer. So I knew that when I started college, I wanted to go to law school. So I had a lot of advanced credits from high school, and I ended up graduating college, knowing that I would in 3 years. And then I was looking at UVA Law School or Richmond Law School, and the folks around me at the time, we mentioned Craig Cooley early, he was one of them, Ned McCullough as well, said, if you want to practice in Virginia, go to the University of Richmond. Because even then, UVA had a more national focus and global courses and that sort of thing. So Richmond was my choice. And then I went to the University of Richmond and knew when I started at Richmond that I wanted to do some sort of litigation. I actually thought that I would be a criminal attorney. Clerking 1 year for the Court of Appeals dissuaded me from doing that, and I ended up always practicing civil law. But my path, for whatever reason, was ingrained in me from a young age that practicing law was what I wanted to do.
That's awesome. And it sounds like specifically being in the courtroom, too,
That's correct.
Right?
Mm-hmm.
That's awesome. Not many people are lucky to know exactly what they want to do, right? So I'm curious, synchronized swimming, that sounds incredibly difficult. Every time it comes up, it's during the Olympics, right? You see it, because otherwise it's not on TV. At least it's not easily available on TV. How hard is synchronized swimming?
Well, it is difficult, but the whole point of it, like figure skating, is you're never supposed to look at it and say it's hard, because I was recruited to Richmond for speed swimming, and I was burned out from it. And I met Peg Hogan, who was the coach, and she was also a national judge for synchronized swimming. Fell in love with her. She was just a very unique personality. And I tried out for the synchronized swimming team. And of course, I'm looking around at these other young women and I'm like, I can swim. We start doing laps and I'm much more advanced than these people. And then I'll never forget, Peg hands me a nose clip and I'm like, oh, please, I do not need a nose clip. But when you start to stay under the water upside down most of the time, that nose clip comes in handy. So I did apologize and then asked her again for this nose clip and learned a lot. I enjoyed it. Sororities weren't real big at Richmond. They were just starting at the time, and the team was my sorority, my group of people. I'm still friends with many of them to this day. And the University of Richmond was a nationally ranked team. When I was there, we swam against Stanford University, Ohio State, colleges in Florida, Wheaton College, William & Mary had a team, and it was a varsity sport. We had daily practices. We had weight room schedules that we had to follow. It's a little different than things are now. We were weighed in every week.
Oh, wow.
And we had...
And what was the purpose of that?
It was just fitness. We had a lot of breath control versus when I was speed swimming, like we would do what's called unders and overs, which the entire length of the pool was under, and then you'd swim back. And the goal was, even when you were swimming back, not to breathe every stroke, was to breathe every 4 or 5, 6, whatever you could do on the way back, because breath control was super important for the routines. Because you don't want to be struggling when you're under the water, and then when you come up, shoulders are out and you want to be smiling. And the whole thing is not to look like you're struggling. And that took getting used to, because in speed swimming, nobody cared what you look like. We did that, and we were a team. We had costumes and headpieces. Back then, we would put gelatin in our hair to keep it hard, even though we were in the water and getting wet. But it was great. We would travel to various meets. We were in, I think it was called the Collegian. We'd have photos in the Collegian based on our rankings. And I was not a nationally ranked synchronized swimmer, but some of the girls that were recruited to Richmond were, and I would learn from them and swim along them, and it was great. And I actually did synchronized swimming as a master synchronized swimmer. So I swam with Peg Hogan, with Laura Souls. And so at one point, it was like 20, 40, and 60 years of age on our team, along with other people. And
Wow.
I did that until after I had my second child, and then I was just too busy with work and children. But he was born in 2001. So I started swimming in 87 and continued it. And there's still an offer for me to come back and do their master's team. They still have a Richmond team, but I have not yet taken them up on that.
It looks so incredibly difficult, especially for me, where my version of swimming is going down a water slide and maybe doing a half lap, because I recognize a whole lap is there and back. But no, I'm always very impressed.
It was great, and I really enjoyed it. And I didn't know that you could hear the music under the water, but we had an underwater speaker, and it also involved choreography. You would have to go to Peg's house and record your music, and then she would help you, and we would have choreography practices where that's all you would do, and then you would practice the routines. And it was definitely an experience, and it enhanced my time in college.
Absolutely. It also sounds somewhat similar to trial work, right? With the discipline, the preparation, because going to court's a show to some extent.
That's
right?
exactly right.
And that's what we're doing. And I'm sure things happen during synchronized swimming that aren't supposed to happen, and then you have to adjust, just like in a courtroom, right?
That is exactly right.
So how did you end up finding personal injury?
I didn't start that way. I clerked for the Court of Appeals, and back then, very different than now, it was criminal, domestic, and workers' comp. And my clerkship told me that I liked the trial work. I didn't love that area of the law. And my first job out of that was with a gentleman named Ed Taylor. And he was one of the first of there's only about 3 or 4 lawyers, all men in Virginia, who specialized in medical malpractice. So for the first 10 years of my practice, all I did was medical malpractice. I did not go to general district court. That's not how I started. I went to work, and within 2 months, we had a 6-day trial in Richmond Circuit with Judge Harris, and I was handling the family members. Couldn't believe it. But that's what happens when you go to a small firm and not a big firm.
You get that immediate level of responsibility,
exactly,
which is incredible.
And I thrived on that. So we did all big catastrophic cases. I did a ton of baby cases. I was there about a year. And for the good or the bad, Ed did not send me to trial classes. He sent me to med school. I took a class, like 3 days on reading fetal heart monitoring strips. I took a class on medications and dosages in different parts of the country. The fetal heart monitoring was in New York. The other one was in Boston. And we had a law library at the office, but we also had a much larger library of medical books, because he taught me that before you ever reached out to the experts, you had to at least understand the medicine yourself. And when I was first in practice, not many people know this, but I had a library card to the MCV library. We didn't have the internet. And every weekend, I would take...
What is a library card? No,
exactly.
I'm joking. But,
Because I think
I may have a library card.
Lots of people have to go to, and the University of Richmond Law School has a fabulous library. I didn't go there. I would get my card, and I would look at the notes. I would talk to people all week long, and they would have heart cases, medication overdoses, baby issues, whatever it was. And then I would drive to VCU MCV, and I would spend hours in the library reading. And then my first experts came from names in textbooks. So
Wow.
I am thrilled that now you can get that stuff online, and you have PubMed and all sorts of medical abstracts and stuff. But Dr. Google did not exist when I first started practicing.
And MedMal, I've dabbled very briefly, and even once with yourself, and like it is hard.
Case selection.
It's case selection, but then something that's really blown my mind, I still have yet to understand what a good MedMal case looks like. Because, for example, the case that you and I considered working on a while back, to me, it was like, all right, you got clear negligence, but then you got the causation issue. I have yet to come across a MedMal case from Slam Dunk, or even in my mind, it's Slam Dunk. And then
Defense always disagrees with you on that assessment. But
and you still handle
I
MedMal
do.
today, right?
It depends on the year at this point, but I am very capable of doing a med mal. At this point, I would say my practice focuses on catastrophic injury and wrongful death. And thankfully, because of my experience, because of the firm that I work at, it doesn't matter if that's a med mal, wrongful death, or catastrophic injury, or a personal injury, wrongful death, or catastrophic injury. We do our best to limit our cases to catastrophic injuries. It's just we're not very big at the firm. We have good support staff, but we don't have a huge number of support staff. And so we focus our resources on the larger cases. I have handled GDC cases. I don't do a lot of them, but of course, with the raising of the limits in GDC, that certainly helps. And sometimes after my many years of doing med mal cases, it's nice to have a case that resolves in 6 months or a year. Med mal cases can take 2, 3, and 4 years. So now my practice, some years it might be 50-50 med mal, personal injury. Some years I might not have any medical malpractice cases, and some years I focus on the med mal cases. Unfortunately, because of the cap and because of the amount of money it costs to bring forth med mal cases, most of them are injured baby cases or death cases or loss of limb cases, just because you have to have large damages in order to effectively or appropriately pursue them, because it's a risk-reward system.
No, absolutely. And I imagine in a med mal case, it's probably common to be looking at cost numbers of closer to $100,000, right?
Or, more. When you actually try it, it's well over 100.
Do you see that cap going away anytime soon?
Right now, we're about at 2.6 or 2.65. So we have an agreement in place to go up to 3. And there's some rumblings in the General Assembly. We're still in January, so we'll see what happens. But it will change. I know that it will change in the upcoming years. It's just a question of how. It's very difficult to handle a baby injury case in Virginia when you have a life care plan that's literally 5 or 10 million. Or if I handle a death case involving a 40-year-old breadwinner and my economic loss is 5 or 10 million, and I simply can't get that. I've gotten verdicts that are 5 million, 5.5 million, and you never saw it rolled back so quickly as when it drops to the cap. So in that regard, it would be nice to have changes that simply acknowledge economic loss or life care plans. But we have to be careful in Virginia, because right now, when I'm representing, for example, right now I have a case of an 80-year-old man, I can ask the jury for $5 million. And I can't get $5 million, but I can get whatever the appropriate cap amount is. But if you're in other states, you might get $250,000.
No, there are states that are worse off than Virginia.
So now they do, when I go to national.
Even California, it recently changed, but of all places, and Texas, I know too, is very difficult.
But in some of those states, if you have an economic loss, you can get it.
Right. And they just cap the non-economic.
Correct. When I attend national conferences and they say that for the stay-at-home spouse, you were able to get $1 million, they're drooling over that. In Virginia, we do have an active practice for persons of advanced age, and that's because we're not limited to $250,000 for those cases. So Be careful what you wish for. But yes, the cap needs to go away. It needs to be applied more fairly. I see both sides of it. We talk about it as the three-legged stool in our office. There are many a personal injury case that we take in where the injuries are massive and there's 50 in coverage. That never happens in a med mal case. But if we have the commercial truck, I have settled personal injury cases for $5 and $10 million, which I certainly have never done in a med mal case.
Yeah, it certainly makes for almost an unjustified disparity, right? Obviously, there are arguments on both sides.
I have settled cases involving amputations in medical malpractice cases. Now, keep in mind, I have been around a long time. So when I started, the cap was $750. Then it went to $1 million, and then it went to increments up to $2 million, and now we're going towards $3 million. But I have settled double, quadruple amputation cases for the cap, which at the time was $1 million, 1.5. And then I have had personal injury car crash cases where there's an amputation, one limb, and I can get $5 million if the applicable coverage is there.
No, it's a wild world. But no, Virginia does have good laws for the most part. The collateral source rule is great, right?
Contrib.
Yeah, contrib. I'm not as afraid of it as I think maybe some are, but the 1% is tough on premises. That said, and when I go to the national conferences, people are like, contrib is, they're scared to death of it. And it's because they have practices that are used to, their clients 35, 40% at fault, and they're still recovering something, where here the firm would be dumb to even take a case like that.
Exactly.
So
it all boils down again to case selection, even in that regard.
No, absolutely. And of course, joint several is helpful too, right? I have never been a fan of the caps, and maybe because I come from the perspective of just let the jury decide, let the judge decide, right? Same thing when it comes to the criminal side. I recognize that there are mandatory minimums and that Congress says, yes, there are mandatory minimums. But my thought is we put judges in these positions, let them decide. But anyways, people can go back and forth.
I don't like it also because the reason why we have a cap in Virginia is because of the lobbyists for the healthcare providers and the hospitals. And what I don't like is I saw it 25, 30 years ago when you had the doctor who had his own practice and their argument was we're running doctors out of business. Now, why should an HCA or a Bon Secours or a Carillion that has billions of dollars in profit get the benefit of the cap?
No, that makes sense.
When have you seen the small town doctor anymore?
I don't even know if they exist.
That's exactly right. So then the argument of 30 years ago, which was we need to protect the doctors, that's gone.
It's interesting. The punitive cap has some similarities to that too, right? In Virginia, it's $350,000, which I think is relatively low compared to a lot of places in the country. But the idea of punitives is there's three things. There's punishment, there's deterrence to the individual, then deterrence to the community, society, right? And $350,000 to an individual, to most individuals, is crushing. $350,000 to Ford Motor Company, to L.E. Myers, to any of these massive corporations is nothing. Or I take that back. It's not nothing, but doesn't have the same deterrent effect, right? So it makes you wonder, what's the point?
That's true.
But and I wonder if that will change. I don't know. One can hope and dream, right?
That's exactly. See, I started in the cap with $750, so I'm not going to sit here and say, "Oh my God, $2.6 million in a baby case or a death case is huge." But I do see that we have come a ways from what we used to be, but we still have a ways to go.
That's right. When you're looking at a case, how do you value it? And I recognize it's a loaded question. There's no one right answer. But when you're coming up with a number that you think case is appropriate to resolve for, what are you looking at?
There is a difference between PI and med-mals. So when you're asking me that question, because all med-mals have to be evaluated against the cap. So that does change my mindset. For example, if you have a PI case with a broken bone, you're thinking hundreds of thousands of dollars. Double broken bones, legs versus arms, you're calculating hundreds. In med-mal, oftentimes broken bones can be 300 to 500, even though we have this 2.5 million plus cap. And that's because on the scale, broken bones heal. And if the person's not limping and they're able to go back to work, on the sliding scale of a med-mal case, that's going to be one of those injuries that gets repaired and the person can still have a normal life. It's different ways to value it. But in terms of valuation as a whole, I use my 30 years of experience, and then I do talk to people, other lawyers, listservs.
Well, and you guys also, correct me if I'm wrong, but you focus group a lot too, right?
That is correct. So that's what I'm going to say. I may have something in my mind, but then I reach out to others and listserv, other comparable verdicts. Well, I was just looking at one today, comparables for deaths of elderly persons. And then I've got focus groups lined up. Thankfully, I do have an in-house focus group company, which is awesome. Through Joseph Cantor and Irv Cantor, thanks to them, we have jury impressions, and that is an awesome resource to have. We use it for value. It's also super helpful for trying issues that may come up in a case. It's so interesting to be a fly on the wall and to see things that we gloss over, like topics or issues, and they focus and drill down on it, and then you can just fix it by the time that you try the case. So that's fascinating to me. And sometimes their focus groups aren't as good for evaluation as they are for issue spotting,
right?
Simply because no matter what, when you have that jury and there's one person in there who has a personal experience for the good or the bad, it just depends what it is. Sometimes that affects the whole panel and you just can't focus group that as well. It's better when there isn't like one polarizing person in the focus group when you're talking about value. If everybody can get together and have a true discussion, sometimes that can be ruined by one person. But I love doing focus groups, and the fact that we can do them relatively easy in-house through jury impressions is a phenomenal resource to have.
No, it's incredible. And I'm starting to see it more common. Like you're starting to see more vendors offer it. There's now the big data stuff, which is interesting. I've been a part of a few, and I agree. Like the insight's incredible.
But you have to do it right.
That's
One of the things that folks do wrong in focus groups is you cannot make it a one-sided presentation. Right. You have to be neutral. You can't make your argument 50 pages and then the defense argument 10.
Right. Garbage in, garbage out.
Exactly.
Right. So
or one side. You've got to try your best. When I do a focus group, I do the defense side first because it has to be there and it has to be strong. And then I go back to my case because I know my case. But yeah, you've got to have the right information in front of that jury, even if it's swayed more to the defense, because that's the only way you get a true read.
And maybe that's even the better approach, right? To have it more defense friendly. So you really are testing your case. There are firms I've seen who will say, if you're not focus grouping your case, you're on the edge of malpractice. And I don't know what the line is for malpractice, but they've got a point. They've got a very strong point. Why are we going to show up to court never having tested what we're about to do when you look at, I don't know, name your youth league sport. These kids practice 3-4 times a week before they show up for the game, yet we as lawyers, for some reason, think we can just show up and make it happen, which is just not true.
And sometimes you just get set in your ways or you weren't doing them before. I can tell you that on some personal injury cases that I don't focus group, it's simply because my coverage is limited. And if I know that I can get whatever that coverage is, I may not need to focus group that case. But all med mals, are focus grouped.
That makes sense. And then I imagine also the more that you are involved in focus groups, the more issues presented. And then you probably see pretty consistent reactions by the jurors, which probably helps give you the confidence to say, you know what, this case may not need to really delve into that issue as much.
And then it is helpful to find out when I'm doing a sexual abuse case, oftentimes you think, oh, men are better on the juries because they want to protect. But in certain situations, you might have, it's better to have women on the jury, that sort of thing. I was just focus grouping for a med mal case and the women were much better than the men, and that was surprising. So that could help you, not just in presenting the case, but how you pick your jury.
Absolutely, which is massive, right? I tell people all the time, and I have to remind myself that the only people who get to make any sort of real important decisions during the trial is the jury. They're the ones who fill out that fancy worksheet at the end. So we got to make sure we have the right people for that specific case.
And I think voir dire, Irv Cantor always said it, and I've adopted it. And it's funny, like a lot of defense lawyers will, and even some plaintiffs' lawyers, they give voir dire to the young associate because you write out your list of questions and then the associate can ask. But voir dire is an art. And it really, truly is your opportunity to be eyeball to eyeball with the people who are going to fill out that fancy worksheet for you. And you build your rapport. And I love voir dire. I tell folks that if they want help with voir dire when they're coming into Richmond, Henrico, Chesterfield, look me up, and several have. And so I am happy to help. And it's also a lot of moving parts and pieces, and you got to find out who was nodding and who was paying attention and who answered the question and who didn't. And so you've got to have whatever is your... I have never seen anybody do voir dire perfectly on a computer. To me, it's back to the old open that billfold or whatever, that red, whatever it is, and then you make your notations in red, blue, green, et cetera, et cetera. But those are the folks who are going to decide the case. And after I do voir dire, then my focus is all on my client, my witnesses, my experts, the defense. And so I love that opportunity to connect with them, to let them in a little bit on who I am and why I'm proud to represent this person and start the story. And there is some part of that voir dire that's going to be in my opening and some part that's going to be in my closing, whatever, some catchphrase or something, the theme of the case, whatever it might be, but you've got to connect with them right away.
preaching to the choir. So I think almost every episode of our podcast, voir dire is mentioned, and it's an opening. I think what's interesting is when I was first learning how to become a trial lawyer, there's a handful of textbooks say, well, write out your closing argument. And then everything is based off of your closing, and you're saving everything up for closing. And I've come to learn over the last few years, it's the exact opposite. It's voir dire, opening statement.
Yep.
Voir dire, you're building the credibility. You're bringing out issues in your case, right? You're also framing your case. Opening, you are doing everything you can to tell a persuasive story, especially as a prosecutor or a plaintiff's attorney, because you get to go first and you get to set the lens. Your first few witnesses, or you ideally want to build credibility off of your opening to support what you said in opening. And then you're telling the story of the case. And then in closing, what I've adopted, and I forgot where I learned it from, but you are now arming the jurors on your side for the real closing argument, which is in the deliberations room.
Correct. Absolutely correct. And I will tell you, in one case, for whatever reason, many years ago, I didn't do it or I did it, but not to that one person. But I'll never forget, I had a trial in Richmond Circuit, ended up being a defense verdict in a med-mal case. But the foreperson ended up being an all-male jury, but the foreperson came out and sat by himself when the verdict was read, and then the jury was polled, and the foreperson asked if the bailiff could walk him to his car. So I had gotten these others to support me, but somehow they didn't have enough ammunition to override this gentleman's decision. So it wasn't the one lone holdout. He was able to do a better job and present the defense argument better. And I always learned that lesson and said exactly that. I've got to give them enough of the arguments in my closing that, hey, you may have heard the defense say this about standard of care. This is the retort to that. Hey, You may have heard them say this about causation. This is your response to that. And this is why they're wrong. And here we are.
No, that's, 100% right. And it's a lot of fun too. But
I love trying cases.
Yeah, it's a lot of fun.
So much work to get there. But when you're actually there, it's so invigorating, so exciting. I barely sleep. My paralegals and everybody are amazed. And I don't drink coffee. So I'm a trial lawyer, maybe one of the few out there. I don't drink coffee. I don't sit there and drink Coke and all this other stuff. It's just me. That is what excites me. And I do tell my kids that, they're all adults now, that I love what I do. And so I don't feel my age when I'm at my job. I go to work every day and enjoy it. I don't want to work from home. I want to go to an office. I want to meet my clients in person. Before our podcast today, I was at Henrico Doctors Hospital visiting a client. If you're passionate about what you do, I'm not going to say your work isn't hard, but if you're passionate about what you do, you're going to sit here at a podcast and say, I can't believe I've been doing this 32 years. It feels like yesterday starting. And I remember trials from 1995 and 2000, and then I look at them and say, oh my gosh, that was 25 years ago. I had trials leaving 3 children under the age of 6 at home between my husband and my parents. And you got to like what you do if you're going to put yourself through being away from home, being in a hotel room. But when you have work that you feel like you're helping someone, if I can come home after being in Norfolk for a solid week and you get there on the weekend and then you spend the week in court and you drive home and the kids are like, did you win, mommy? And you say, yes, I did. But then I say, and I helped this little boy. And to this day, that little boy, who is now a high school graduate, sends me photos and things that he's doing, but he doesn't have his complete mental faculties. But he has been, with the money that we achieved through his award, he's been able to go to special schools and he's studying to be a personal trainer.
That's awesome. I feel the same way about this practice area. And I hope and wish that everyone could find something that they just genuinely enjoy doing.
Being a paralegal for Stephanie Grana is not the easiest thing because literally 5 o'clock comes and goes. And then they might be in the doorway saying, at 6, do you need anything? And I'm like, I'm so sorry, it's 6. I have no idea what the time is. And being my husband is the most difficult job because, Steph, we're supposed to be at dinner. And I'm like, oh my God, I just got this great call. I got to do this. I got to do this. And I got to do that. He's tell me your appetizer and I'll take care of it. But please then get in the car and come. He's a very patient man.
And also a lawyer, right?
Yes. Yes, he does divorce, custody.
Okay, so very patient.
Exactly.
Yeah,
in
very
practice,
patient.
yes, personally and professionally, there you go.
Yeah, that's awesome. So can we talk about building a practice? I mean, you've done an incredible job and you're everywhere, right? You've State Bar, all types of places.
VTLA,
right? VTLA,
Women's Bar.
AAJ, I'm sure Aboda probably too, right?
I was president of Aboda.
There we go. So at what point did you decide this is what I'm going to do to build a practice? This is how I'm going to put myself out there. These are the organizations I'm going to get involved with. What was that thought process like?
It wasn't as strategic as you have just led into the question to me. It's not as strategic as when I build a case and I'm prepping for a trial that might be 9 months down the road. I became active in organizations that I enjoyed. It was not a plan to, if you become president of this, people will see your name and hire you. It was just being active in organizations. And then to me, to be active is to do the work and then they put you on the committee. And then you do the work on the committee and all of a sudden you're in the line of succession to be the president. And every time I've been president of an organization, I've done it to make the organization better. And now when I look back on my resume and I talk to younger lawyers, I have to tell them that my goal was not to be the president of 6 different organizations. I did hope to become president of the Virginia Trial Lawyers Association once I joined that organization. I never thought I'd be state bar president. I didn't know I'd be president of Aboda. I didn't know I'd be president of the Commonwealth Community Trust Organization. But I was active in those organizations and I wanted to leave the organization better once I became the president. And so in hindsight, in doing that, you look at your resume and you're like, oh, wow, look at all these things that I've been active in and then I became the president in. Lewis Powell, Inn of Court. First, I started in the John Marshall and then we split into 2. And that was just a great organization to meet older lawyers, to meet judges, to have an appetizer with them, have a dessert with them, and then to attend great legal programs. And then I said, I want our program to be this. Let me do what I can to put this program on. The next thing I know, I'm in charge of programs. The next thing I know, they're asking me to become the president of the new Inn of Court, which then became the Lewis Powell Inn. So it wasn't...
Yeah, it wasn't strategic. It was you wanted to do work that you enjoyed and be around people that shared that passion, and you did it. You put the work in, and then suddenly new opportunities showed up. And along the way, you met a ton of people.
That's exactly right. And then I have to say, as a woman in this business, and there aren't as many female trial lawyers, there's many more now than when I started, but I also married the right person. And we would attend things together. And I do encourage young trial lawyers to do that. Yes, there are many people out there whose husband stays home or the wife stays home, but Scott and I really would do that together. Now, he's not president of all of these things, and he is a tremendous lawyer, and he has amazing friends, and he is a Virginia-ranked golfer, and he knows where his passion lies, but he was supportive to me and had other friends in these organizations too, and we would attend together. And I say that all the time. We would turn the cocktail party into going out to dinner with friends. And then when I had children, I always say this to them now, that between the age of 0 and 5, they attended more cocktail parties than they will ever remember. But I would bring a baby in
because of their age or what they drank?
Because their mom was going...
No,
I'll never forget going to the Lewis Skinner Botanical Gardens, and I would bring that car seat in and literally put it on, not the table with the hors d'oeuvres, but on one of the tables. And I turn around and Cleo Powell is holding Nicole. I turn around and John Gibney is holding another child. And I know they're in good hands because it's lawyers. And then I get to go to all of these events. I think that's what's interesting is you've got to incorporate family life into what you're doing if you can. I was able to do that, and that's the only way I was able to do the things that I did. So for me, it really wasn't a plan. It was doing the things that I enjoyed, and there are many people who their enjoyment lies outside of legal activities. And that's fine too. But for me, it was just, these are the things that I like doing. I like being a part of them. And it's in my DNA. I end up becoming the president. I say yes to the different options that are made available to me. And then I'm willing to do the work.
And I think it's probably fair to say that your hobby is trial work in some respects. I've actually had to come to terms with that. It's because there's like this, oh, you work all the time. And there's a guilt that's associated with it. I like it. So it's okay. You're not going to find me playing video games. You're not going to find me on a golf course. Like, I like work, and that's okay.
Yeah, we'll join our own support club here.
Yeah, I know. We could have, I'm sure. I think there's a trend, right? Like you see people who are former athletes find themselves in law school and then find themselves in the trial practice.
And I say I like gardening, but I think that is where I take out my frustrations, because I end up weeding more than gardening, and you're pulling and you're getting out there and you're sweating and all the rest of that. And it's just, I think I'm letting my frustrations out from those defense attorneys that I'm dealing with.
Absolutely. Or the insurance company. It is surprising to me, just one, how different the interactions can be between adjusters, defense attorneys, insurance companies, and it just ranges. It's always new. It's always something different. Some cases are easy, some cases are not. Have you seen over your time that simply just through your experience and reputation that you are treated more seriously when it comes to negotiations?
It depends. I do see that with lawyers that I've known for years, or younger lawyers who look me up before we get involved in something. But sometimes the insurance companies, they just don't care in that regard, and they have a number they want to pay or what they want to do. And it doesn't matter if you're 2 years out or 25 years out. I've always made it my practice over the time I've been a lawyer to do my best to get along with the other attorneys. It's no fun in a case, and I've had it, but it's no fun when you're dealing with a case and you keep beating your head against the wall with an attorney. Because in med mal, especially, those cases just take so long. They take multiple years. So I do my best to state my case, but I understand they have a job to do. I have a job to do. But you really just can't take it personally in that regard, and just do your best. But I would love to say that this many years out, everybody respects you and they value your evaluation of the case, but that's not always the situation.
Do you think they take into account trial history? And when I say that, maybe just a general gauge of willingness to go to court.
I would hope so.
You think so, right? Because what is the insurance company most afraid of? It's the uncertainty of a jury, right? But who knows?
And it's difficult in med mal because in some of those cases, they say, okay, we get hit with the cap. It's not as bad as in other states, or because these companies are national companies. And sometimes we just don't see eye to eye on the cases. I love trying cases. I'm happy to try cases. Unfortunately, when you're dealing with insurance company limits or med mal limits, the unfortunate thing is they know how much it costs to try a case. And so sometimes if you're close to the limit of the insurance policy, or if you're close to the cap, it's really hard to advise the client to hold out for that little extra.
For another year and a half, right? And that's probably on the short end.
Correct.
And that value of money.
That's what's more frustrating to me, is the games that are played in that regard in terms of the money. And I only represent people who are catastrophically injured or deceased. And so that $300,000, $250,000, $200,000 means nothing to the insurance company. But me bringing that back to them means a lot. And so it is infuriating when you're close to the policy limits or you're close to the cap, but you just can't get there. And the reason why is you have to take a discount for the cost of trial. Now, that said, I have enough experience that I have enough fingers to cover the cases that I've settled for the cap. In med mal, insurance policies, of course, we get the policies often, but I don't think many med mal attorneys can say that they have settled for the cap numerous times. But I have, and I would like to think that's based on case selection, clients, workup of the case, and experience and working for such a reputable firm. I do a lot of work myself, but I have this amazing team behind me. And I think that's very important when you're handling a case, that every single member of my firm has had multi-million-dollar verdicts and settlements. And I would like to think that when they're coming up against me or one of my partners, they know that.
Absolutely. No, your firm has an incredible reputation. What does the future look like for your firm?
More cases, more trials, more fabulous results. I think we're a very client-centered firm. And it's funny, we all enjoy what we do, and I love the guys that I work with. And the focus would just be helping more people. We don't have any grand plan of, we want to have offices in 3 different cities and we want to grow from this number of lawyers to this number of lawyers. If we add on new lawyers, when we add on new lawyers, they're going to be quality lawyers. But our ultimate goal for all of us is the people that walk through our doors, we want them to be heard, we want them to be respected. And for us, justice is dollars. And so we want to get them the absolute maximum result that we can get for them. And that's the future for us. It would be nice to have some more young blood within the firm because Joe Cantor is one of my partners and I love working with him and being around younger people. I don't feel my age. The fact that I just had a daughter turn 25 this week is absolutely shocking to me. I remember those old lawyers and that sort of thing. I don't feel that
You're not
way.
one of those, yeah.
No,
right?
not me.
Not a chance.
And then I say the only thing that sets me apart from other lawyers is I'm just willing to put in the work. We'll put in 110%. I have said many a time, I am not the smartest person in the room. I am not the best researcher, but I am going to work harder than everybody else on the other side of that table. It's what I do. It's the only way I know how to represent my clients. And until I can't or suddenly stop wanting to put into the work, I'll still be going to my office every day.
It's very clear, I think, not just to me, but to everyone, that you love what you do. You're very good at what you do. And also you care a lot about improving the bar, which is very important. And I know you spent a lot of time and maybe still are involved with the jury instruction committee for Virginia. Are you still working on those?
It's called the VMJI committee. And I did just get retired from that committee, but I had served well over 10 years on the committee, but it's okay. I still have ins into the committee. So I can still make suggestions to the members of the committee, but it's an awesome committee. Reach out to the Chief Justice if anyone's interested in serving on the committee because they do rotate us. But that's another thing, like for young trial lawyers, when you first get your case or you think it's a case that's going to be tried, look at the applicable jury instructions. Make sure you're dotting the I's and crossing the T's. And then make sure you understand the jury instructions, make sure you understand what you have to prove for the elements of the case, for the damages, and build your case around that, because that you'll be mentioning throughout your trial. And that's the blueprint you're going to give the jury to take back into the room when they put a dollar sign in favor of your client. So the jury instructions have come a long way. I know this is a pet peeve of yours as it is of mine. Accident, crash, collision.
Yeah, I'm on a crusade. I think I've got, how many orders do I have? I think I have 2 orders now, but I'm working on a few more.
And I will do my best to get more in there. But I think it's important. And then I also have the issue in med-mal cases where you have the 35 instruction that says the mere fact that there's been a surgery and a bad result doesn't mean the doctor's negligence. And then you've got the mere fact of accident. In med-mal cases now, defense attorneys are trying to get both in. So, I don't need the jury to be hit over the head twice with the fact that, just because there's an injury doesn't mean anybody's at fault. So, we have a ways to go with some of the civil instructions, but it was most interesting to be on the VMJI committee. We also have to do criminal instructions.
Right.
So I learned a lot about drugs and the drug chapter, more than I ever thought I could know, wanted to know, etc. Craig Cooley held my hand a lot for those. And he is responsible for changing guilt phase to penalty phase. He thought that was a little biased, and it was. But you don't know these things until you sit down and study the instructions. And
Well, and words matter too. Words really matter, especially when you're talking to a jury, right? I mean,
but I remember being a young trial lawyer and being handed this book, and then I would look at old jury instructions and then look at this book. And now to know that I've looked at and worked on like all of the chapters in the criminal and the civil, and you really do see how they weave together. And that helps you tell the jury the story of the case. It also makes you a better oral advocate to the judge to say, Judge, this says the same thing as this. We don't need both. But you can't do that the night before jury instructions when you're in the middle of trial. You have to work on your jury instructions starting with the case.
Absolutely. I have a wish list. Maybe I should send it to the Chief Justice. Is that it? But
there you go.
It's really been a pleasure having you. Before we close up, there's a lot of young lawyers and law students who listen to this podcast, and we're grateful for you guys. Thank you. If they want to become a trial lawyer, follow your path, what are you telling them to do? What advice do you give them now? Because a lot of law students, for example, and even young lawyers, they've got crippling debt from law school. Law school prices are absolutely insane. I think when I went to UVA, it was 50-something a year, and I graduated in 2014. I think I looked back a few months ago. I forgot how it came up, but it increased by like 25 grand. Like it's insane. Wild.
I did have a daughter who just graduated.
Oh, so you know better than I do. So, but if you want to be a trial lawyer and you are a young lawyer or a law student, what do you tell them to do?
I think use your time to observe. I think it's very good to go to general district court, circuit court, and just watch. And that can help you to determine if that's what you want to do. When I was in law school, I literally took the bus from the University of Richmond to downtown Richmond Circuit, and I observed. I loved watching Colette McEachin try cases, and it solidified that I wanted to be a trial lawyer. So I think the more times that you can get into court or email me, email you, and say, hey, when's your next trial? Be it a jury trial, a bench trial, whatever it might be. Law students have watched my husband in divorce cases. It's very different to have a bench trial versus a jury trial, but you still have presentation of evidence, that sort of thing. So I think that's very important. I am not well versed with these pre-law majors and pre-law school things that a lot of colleges are putting out. I think it's good to, in college, major in what you want to major, get good grades, enjoy your college experience in that regard. English majors, when I was in law school and to this day, seem to turn into lawyers often. And I think, as we just said, words matter. So it's helpful for English majors. I was a criminal justice and sociology major, but I knew I wanted to go to law school. So it worked out fine for me. But I think evidence class is key. Civil procedure is very important in law school. And then I think, which law schools allow you to do more so now than when I was there over 30 years ago, is get experience. You have 3 years. The first year is tough, but the second year gives you more freedom. The third year gives you even more. Get your third year practice certificate, hook up with older lawyers in various fields. If environmental is what you want, reach out to one. If you want to do some sort of divorce custody type case, reach out to a lawyer. The professors are pretty local at most of the law schools. Reach out to them. But I think to work under an attorney just to observe is invaluable. Use the summers to get internships. I understand everyone's in debt and internships are not the best, but you've got to figure out what you want to do, where your passion lies. And I think that's very important. I'm trying to think. The other thing is, when I was in law school, wellness and health was never talked about. I was told and trained, do not leave the office till the senior partner leaves, even if you're doing nothing. It was not my job to leave before the senior partner. And thankfully, I think that we have changed our mindset in that regard. And I pity the young lawyer who has to stay until I leave the office, because that would just be a nightmare often when I don't leave till 9 or 10 at night. I'm on a first name basis with the cleaning crew at our building. And the head of the cleaning crew, he calls me Miss Stephanie, and we have conversations. And I've gotten some case referrals from the cleaning crew. But I think a healthy lifestyle can be started because no matter what, especially trial lawyers, it ebbs and flows. So if we have a trial coming up, we work late. But healthy habits will enable you to last longer in our business. And I also think that you have to have a competitive edge to be a lawyer. So why not also use that, whether it's Taekwondo or Pilates or ice hockey or running or weightlifting, whatever.
Synchronized swimming?
I don't do it now. It's hard to do synchronized swimming. I learned that. It's hard to do it in the middle of the day. So now I do Pilates.
Got it.
And I do weight training so that you can have a job, do that, maybe come back to work or do it in the morning before work. But you always have to find the pool when you do the synchronized swimming.
That's true.
But I have an open offer to do masters again if I want to. I just haven't done it. But I just think and I told my daughter this when she was in law school, say yes to anything that's offered. Try the trial team, try the negotiations team, try the drafting of contracts, whatever that involves, to figure out what you want to do. Just get experience anywhere you can, as best you can. And then I worked in the law library when I was there to have some available funds when I was in law school. So I always worked and took the classes and stuff. But I just think that, again, there are so many avenues in the law. We trial lawyers are a minority. But if there are law students listening to the podcast, I hope that means they have an interest in trial law. Sometimes I feel like it's not the favored part of the law and folks aren't going into trial law as much because it is hard work. But to have a client at the end of the case say thank you and to know that they now have the financial resources to help them improve. I can't tell you the number of clients I've had. Wheelchairs are so technologically advanced, but they are so expensive. And if that client turns to you and says, I can get the wheelchair that I want, it means so much. It sucks when we lose, but when we win, and hopefully you win more than you lose on our side, it's life-changing. I can't get that from any other job. And to know 10 years down the line, and now I've been in practice long enough, 15 years down the line, somebody sends me a card out of the blue and they just say, I was thinking about you. Or in a death case, they reach out and say, this was the anniversary of his death, and I think of you and I thank you for what you did for my family. That's priceless.
Yeah, can't beat it. Really can't. This has been fun. Thank you so much.
Thank you. Happy to be here. And I will put my name out there if there's any law student who has questions or is interested in trial law or just wants to watch a trial, just reach out.
Thank you for listening to this episode of RVA Trial Lawyers, Virginia's trial lawyer podcast. For more episodes, check out rvatriallawyers.com.